The United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5056. In re Hillary Rodham Clinton and Cheryl Mills. Mr. Kendall for the petitioners, Ms. Kotka for the respondent, Mr. Freeman for the United States Department of State.
This is Judge Griffith, counsel. We welcome you and thank you for participating today. This is unusual circumstances, and we're all dealing with a new way of hearing one another during arguments. So if you will be patient with us, we will be patient with you. Let's begin with Mr. Kendall.
Good morning. May it please the court. This is David Kendall. I represent petitioner, former Secretary of State Clinton. I will also be presenting argument this morning on behalf of co-petitioner Cheryl Mills. I want to first address the two questions this court identified in its May 14th order that I wanted counsel to focus on. First, mootness. This case is moot for a number of reasons. First, the petitioners have no emails whatsoever left to produce. Nobody disputes that. In December 2014, at the request of the State Department, Secretary Clinton provided all of her then existing emails that were either work-related or potentially work-related, and Ms. Mills produced all of her records in 2015. Secretary Clinton has declared under oath numerous times that she's produced all such emails in her custody, and respondents make no claim that petitioners have anything left to produce.
Mr. Kendall, this is Judge Griffith. But on the record before us, how can we hold the case as moot? Judge Lambert's most recent order noted that the State Department continues to produce new emails, and one of those suggests that there may be undisclosed text messages as well. Typically, we require jurisdictional facts to be determined by the district court, and hasn't Judge Lambert here found that there may be more out there?
Judge Griffith, three responses to that. First of all, it's true that the Department of Justice in the December hearing said it couldn't identify where some of the emails the FBI had given the State Department came from, was still working on it. But the Department of Justice has now determined these are not new at all. These are not new emails. In a recently filed memo in another Judicial Watch case, this one before Judge Walton, Judicial Watch versus Department of State, 12-CV-2034, imposing Rule 56D discovery, the Department of Justice filed a memo on April the 30th saying, that these emails were not new at all. They've been in the possession of the State Department originally. Second, the standard in FOIA, as this court has said many times, is not one requiring the absolute production of every possible record. What's required is a good faith search, and a good faith and reasonable search. And the fact that a few documents turn up later does not impugn that search. And finally, with regard to the text messages, there's really, again, these two petitioners have nothing to contribute there. All of the existing, the Secretary's existing cell phones were given to the FBI in 2015. Those have been analyzed. Judge Boasberg found in the Tillerson decision, which was the case right before that came up to discourse Pompeo, that the FBI had searched the phones the Secretary turned over, and none of the phones contained relevant records. So I think mootness is clear. I think it was clearly established in Pompeo when the court affirmed the decision of Judge Boasberg dismissing the suit brought by Judicial Watch to compel production of records under the Federal Records Act. 2 years earlier, the court had reversed and remanded an earlier dismissal to see if any more emails could be obtained, quote, by shaking the tree, close quote, as this court put it. The district court then conducted further hearings and ultimately concluded that no imaginable enforcement action could lead to the recovery of more emails.
Mr. King, I'm going to direct your attention to Judge Lambert's order, and I'm looking at the carryover paragraph from page 1 to page 2 of that order, and I'd like you to respond to this sentence at the bottom of page 1. State failed to fully explain the new email's origins when a court directly questioned where they came from. Is that accurate, or?
It's accurate that the petitioner the counsel for State Department, Mr. Pezzi, said that they were still working on the origin of those emails. So I think it's accurate. This order was filed, Judge Lambert filed his order on March the 2nd. But as I mentioned in this other case, and Judicial Watch should be well aware of this, the department has answered that question by saying these emails are not new at all. They were formerly in the presence of, in the custody of the State Department. So I think it's clearly the Justice Department has closed that loop.
And then the next sentence, furthermore, State has not represented to the court that the private emails of State's former employees who corresponded with Secretary Clinton have been searched for additional Clinton emails. Is that accurate? It's not entirely accurate because, as Judge Boasberg's opinion in Tillerson, and that site is 293 F sub 3rd 33 at page 45, as Judge Boasberg reviewed, indeed the FBI has searched many and has interviewed many of the people with whom the Secretary emailed. So they haven't. I can't say that they've interviewed every last one, but certainly emails have been collected from a variety of sources, which typically duplicated the emails we turned over from the Secretary's server in December of 2014. Okay, thank you.
Mr. Kendall, this is Judge Wilkins. The follow-up on Judge Griffith's questionings, why wouldn't it be relevant, for the sake of argument, to depose either Secretary Clinton or Ms. Mills to clarify who may have corresponded with either of them or in general about the Benghazi talking points, since that's what the FOIA request is directed to?
Judge Wilkins, for a variety of reasons. One, that information is already available in the emails that State has. Two, from CC, all those people are there and available for Judicial Watch or anybody else to see. Many of them have already been contacted, as I mentioned, by the FBI and interviewed. A deposition about that would have no relation to the one issue in a FOIA case. Are there any more documents to produce? One of the reasons there is so rarely discovery in a FOIA case is that the issue is document production. An agency does not have to explain why it has no documents. It doesn't have to do further work, except that it does have to conduct a reasonable search for responsive documents that are not exempted by one of the 9 exemptions. So the case would be moot because the petition have no more emails to produce. The information is already out there, and this is a FOIA case. It's not some kind of a different investigative case. A search has been done. this court in a 1982 case called Perry versus Block, 684 F. 2nd 121, said that once documents have been produced, we are not authorized to make advisory findings of legal significance on the character of the agency conduct vis-a-vis any requester of information. In sum, if we are convinced that appellees have, however belatedly, released any non-exempt material, we have no further judicial function to perform under the FOIA.
Mr. Kendall, this is Judge Pillard. You assert mootness. You're not asserting that the whole case is moot, but just with respect to the petitioners here, Mills and Clinton?
That's correct, Judge Pillard. We simply don't know. We intervened in the case, Secretary Clinton did, when it became clear that her deposition might be an issue. But the only relief we seek here by mandamus is an order that vacating the memorandum order of Judge Lambert insofar as it provides for depositions of these two parties.
So I'm trying to just, as a sort of a formal matter, understand the procedural posture here. We have a non-party witness, Ms. Mills, and ordinarily one might expect that she would be before the court because she would have been subpoenaed in the jurisdiction where she is present. She would file a motion to quash the subpoena. Then the district court, if the district court denied that, then it would be before us on mandamus from that denial. But I gather that isn't what we have here procedurally.
Procedurally,
can you fill us in on sort of? I'm just thinking about it's unusual. It's not unprecedented, but it's unusual to have a claim that a unit of a case or a subpart of a case is moot, and I'm trying to get my mind around what that subpart is. It's not a claim. It's what?
The subpart is the order directing these two depositions. That was those papers were presented to the judge. The judge issued an order rejecting our arguments on March the 2nd. So, what the question here
there's
is?
There's no subpoena. There's no. Yeah, go ahead.
Sorry.
Go ahead.
No, I didn't mean to interrupt. But there's no subpoena, but certainly. We were a party, the deposition would have been noticed. As we point out, the remedy of contempt, which would have then been available to us, doesn't work because, as this court ruled in the 1998 case in Ray Seelig decision, case which I'm unfortunately very well familiar with because I argued the losing side in the case. That case was a mandamus action brought by then independent counsel Starr. Because we had gotten an order that compelling him to testify, he said that contempt. He said that he had no adequate alternative remedy. This court, and I argued, citing the Papandreou case, just as Judicial Watch does, and this court said not so fast. There said it more elegantly, of course. But it noted that there was no remedy because, first of all, the order wasn't final, it wasn't appealable, and secondly, you couldn't tell whether the court was going to impose civil or criminal contempt.
Right. Right.
So, yeah, if that.
So there's been no. As I mean, you said that deposition would have been noticed, although Ms. Mills is not a party. Is she? She's a non-party witness. That's Secretary Clinton who intervened. So they just asked her, and she didn't require that there be a notice of deposition. Or
I think that after the order, certainly the order was giving Judicial Watch the right to depose the secretary. So I think that is where that's the present posture of the case, and Ms. Mills.
Mm-hmm. And Clinton intervened, so the court had jurisdiction over her because she voluntarily wanted in, and now she basically is saying no, moot, and she wants out. So I understand substantively you're making a claim of mootness, but I'm trying to get, as I said, I'm trying to understand the sort of procedural door through which that goes, or the procedural unit that you would say that applies to. So mandamus is an extraordinary remedy, and I wonder if you have the best case you can point us to where mandamus was granted to prevent a district court from authorizing discovery that was beyond the bounds of relevance in the case. I mean, I know you frame this as mootness, but putting that aside for a moment, if we just look at this as another way of saying these depositions are irrelevant or cumulative or both, there's just nothing that can legitimately be pursued through these depositions, then it really looks more like a case where the question is the district court's management of discovery. I know you cite the Apex doctrine. The district judge was careful to say we're not allowing inquiry into the substance of the decisions that were made. We're talking about finding documents. These are former, not current officials. So I gather the interest that applies here is the third interest, which is, would people be deterred from serving? So I'm not sure how powerfully the Apex doctrine just, for sake of argument, if we were to put that aside, we have a situation here where the district court arguably has gone beyond what is relevant. Best case, mandamus from our court or any court in a case where there's been an allowance of discovery beyond the bounds of relevance.
I think the In re District Court case is certainly one. I think that in the Pompeo decision itself, and that was not a mandamus case, but Judge Boasberg did note that he was applying a mootness standard with more teeth than the FOIA standard. I think we've made clear that there is protection of former officials in a number of different cases. We've cited former governors, former EPA administrators. Usually those cases don't require mandamus because the district court judge grants a motion to quash or for a protective order. Here, mandamus is necessary because, as I've said, it's not an appealable order, and the district court judge himself has determined that the depositions will go forward.
Judge Pillard, did you have further questions? I don't want to interrupt your line.
No, go ahead. Thanks.
So just following up on Judge Pillard's questions, the doctrine about no other avenue for relief because you don't know whether contempt is going to be civil contempt or criminal contempt, and only criminal contempt is directly appealable as an interlocutory order. That line of cases applies to parties, and Secretary Clinton is a party because she intervened under Rule 24, and that was granted. But Ms. Mills is not a party, and so that line of cases does not apply to Ms. Mills. Instead, the line of cases that apply to her is that a non-party is supposed to be subpoenaed and move to quash, and if that's denied, then refuse to comply and be held in contempt. And regardless of whether that's civil or criminal contempt, then that non-party can appeal that order. Isn't that correct?
Judge Wilkins, it's certainly correct that Ms. Mills did not technically intervene. She was treated, though, as a party before the district court, and the order applies to her equally. So I think the arguments that Secretary Clinton had fully cover Ms. Mills, plus the fact that Ms. Mills was deposed at length by Judicial Watch back in June of 2016 on these very same issues. So she has, I think, has an additional claim.
Was that deposition a part of this case or another litigation?
It was a part of the litigation before Judge I believe this is correct. It was before Judge Sullivan, 13-CV 1363. I'm just not certain that in the Judge Sullivan case, there were 8 depositions. In this case, there have been 18 depositions. I just am not certain as I sit up. It can easily check it as to which.
No, I think you're right.
Okay. Mr. Kendall, this is Judge Griffith again. How burdensome would these depositions be?
They would be very burdensome because the issue here, as the State Department puts it, is simply discovery for discovery's sake. They would they're done by video, and they are the real purpose of the depositions is harassment. It's the creation of video footage that can be used for political partisan attack ads and social media fundraising. It's not authorized by the FOIA. It's in a moot case. As the Supreme Court has said, the court doesn't have power to decide questions that can't affect the rights of the litigants in the case before them.
Why does it need to be done by video? Or why couldn't the video be sealed? I mean, if you're right, they're not going to last very long. Right?
Well, there's no assurance of that. Certainly, you could seal something, but the standards for sealing, as I need not remind this court, and as a lawyer sometimes representing news media, those standards are not very reassuring, finally.
Why does it need to be by video?
That has been the practice in the case, I believe, and I haven't been in the case, Ms. Coker can correct me if I'm wrong. I believe most of the cases have been done by video, and it's just a practice in the case.
What I'm getting at is, there is a line of cases out there in which mandamus is used to manage discovery, but in those cases, the interests seem to be more substantial. You have deportation proceedings, you have death penalties. Here, it seems you have a nuisance. There's no question about that. But if you're right, the line of questioning won't last very long, right? It'll be over and done pretty quickly. And so, again, asking this all in the context of mandamus is extraordinary, right? It's a rare device, and even more rare when we're talking about discovery. And so I'm just trying to get your sense of the interest at stake here.
Well, the harassment factor is a real one. Ms. Mills was deposed, I think, for 6 hours. The point is that this does not relate in any way to the disclosure of further documents. Everybody agrees that under FOIA, discovery is very, very rare, only in extraordinary circumstances. So in that regard, I think there is a clear violation that, and I think everybody admits that mandamus is an extraordinary remedy, but it is available when the 3-part test is met. Is there a clear and indisputable right? Is there no other avenue of relief? And is it appropriate under the circumstances? Here, in a case where you've already had 36 depositions in FOIA cases, nobody gets that kind of discovery. The purpose of this discovery, even if it were sealed, is simply harassment. It's not authorized by the law or the court, or by court precedent.
If there are no further questions from my colleagues, we'll give you a couple minutes back on rebuttal, and thank you. And we'll now hear from Judicial Watch.
Good morning. May it please the Court, I am Ramona Kotka on behalf of Respondent Judicial Watch. In light of the Court's order, I will also begin with the issue of mootness. This Court's holding in Pompeo does not moot this case based on the facts that are known today in the record. These facts can be categorized in 2 different categories. One is new Clinton emails, and the second issue is limitations with respect to the FBI's investigations that are relevant in this case. To quickly address the new Clinton emails, It is not in this record that, in the record before the district court, that these emails the State Department had before. And the information that Mr. Kendall had referred to earlier, even if assuming those emails were within the State Department's position at some point, that doesn't answer the question, why is it that 4 years after the FBI closed its investigation, that there are still additional Clinton emails that are being produced? Why were they not searched or located or produced earlier? And that
Ms.
is part of... Yes.
Ms. Kotka, this is Judge Wilkins. What is in the record is the transcript from the hearing when those emails were discussed with the district court, and that's at docket 156. And there, I'm not sure if it was you, but it was counsel for Judicial Watch said that those 30 emails were not responsive to this FOIA request. The quote is, we understand they're not responsive in this case. So you are saying that these 30 emails prove something, but they are not even emails that are related to the Benghazi talking points that your FOIA request is regarding. So what significance do they have?
The significance is that they identify a subset of Clinton emails that were not previously identified or searched. And to answer the ultimate question in any FOIA case is, while the objective is to get to the documents and for production of the document, the issue before the court and the ultimate question is, was there a reasonable search that was conducted? So if we do not know where all the subset of Clinton's emails exist, that is the purpose for why the district court has ordered this additional discovery, so it can be able to develop the record that it needs to reach the determination of what is a reasonable search in this case. And I would just point out that
Ms. Kaka, can I just interject? My understanding is that at the moment when there was an exchange before the district court, the State Department said they're not relevant to this case, and we're not exactly sure where they come from, standing up there, but that then State then did determine that they are not new at all, that they were in the State Department's possession, and therefore they were searched. So I understand what you're saying, that there's this concern if there's a category, even of non-responsive emails, that is showing up belatedly, notwithstanding various investigations and Federal Records Act recovery, then you think, we have a leaky vessel here. But I think that inference is unfounded on the public record, that actually there was no leaky vessel, that State had those, and they were among the body of documents that State did search. So if that is accurate, then I'm not sure I follow the implication, and if it's not, let me know why you think it's not.
Sure. I don't believe that I believe that the record is that the State Department did not search those emails until the FBI identified them in November of 2019. And that's
not my understanding. My understanding is that they looked at them and they realized that they were among the body of emails that they had searched.
I believe that they only looked at them because of the FBI identified them in November of 2019, and that is why the district court in its order pointed to the fact that why are there additional subset of Clinton emails that are being looked at 4 years after the FBI closed its investigation? And part of the reason that the district court permitted the additional discovery is because it was troubled by the fact that the State Department could not provide an explanation from where these emails came from. And to address your question with respect to the fact that now State has come to say that these emails were in its possession all along. However, that's what begs the question here, and the question with respect to the leaky vessel. Because Clinton used a private email and a private email server to communicate while she was at State, her records, even within the State Department, are not known where they exist because they can be dispersed all over the State Department. So perhaps they were on the state.gov email system, but State Department didn't even know when it searched this case to look in those places for Clinton-related emails or Benghazi talking points-related emails. And that is the question here. Mm-hmm.
I'm a little confused by that. I haven't heard that line of argument before. You're saying that you can't be confident in the State Department search because it's unclear where the recovered emails that have been brought back into the State Department pursuant to the Federal Records Act are within the State Department?
No, so the State Department does not say actually where these emails or how it was that it was in possession of these 28 emails. It does not say that it was among the 30,000 emails that Secretary Clinton provided to State in 2014. And it does not state that it was among the emails that were recovered by the FBI investigation. It just says that State Department was in possession of the emails. The question is, was it in possession of the emails because it's on state.gov email address, because the recipient of an email with Secretary Clinton was somebody else outside the Secretary's office, which is the office that was relevant to Judicial Watch's request in this case. So if her records, I'd like to perhaps if I illustrate with the example of the IRS. In 2013, it was disclosed that the IRS had lost years of Lois Lerner's emails. What the IRS did in that case to be able to conduct a comprehensive effort to recover or locate all of Lois Lerner's emails, it had identified 120 custodians with whom Lois Lerner most likely communicated with while she was at the State Department. And Lois Lerner was not the head of the agency. She was just the director of a department. Here, the State Department has searched 4 custodians outside of the emails that Secretary Clinton provided to the State Department. They include Petitioner Shira Mills, Huma Abedin, Jacob Sullivan, and Philip Brains. We know that there are more individuals within State Department even that Secretary Clinton communicated with, and